Very excited to announce a new series with the premier Democratic voting rights attorney in the United States and the founder of Democracy Docket. He and his team led the fight against Trump in 65 court cases in the aftermath of the 2020 election and won 64 of them. Marc Elias. The series is going to be called Democracy Watch. Marc, it is an honor to share the stage with you here, and I'm very excited to help you spread the word about the work that you've been doing.
I'm really excited to do this, and there's no better platform than with you and your audience.
Well, thanks. Well, we're lucky enough to be able to do the first episode here in the immediate aftermath of a pretty bombshell Supreme Court ruling. You represented one of the plaintiffs in what became Allen versus Milligan. So first, can you talk about that case and how the court ruled?
Yeah, so this is a really, really important case if you care about voting rights and redistricting. The state of Alabama, when it drew the new lines for its congressional districts, created one seat that allowed Black voters to elect their candidate of choice. We looked at the law, thought, you know what, there really need to be two seats that allow Black voters an opportunity to elect based on the population and the history of voter discrimination in the state. And that case went to a three-judge panel, three judges originally appointed by Republicans, two by Donald Trump, and they agreed with us. Well, from there, the case went to the U.S. Supreme Court, and today in a 5-4 decision, the court agreed that the Voting Rights Act, Section 2, protects the voters in Alabama and requires the creation of a second district.
Okay, so what are the implications now for Alabama's maps moving forward? Are we gonna see that second majority minority district, and also does that count for both the federal districts and the state legislative districts?
Yeah, so this was about the congressional districts. So we'll see that in the congressional districts. We're also probably going to see that in a couple of other states. Almost certainly in Louisiana, where my firm also sued to create a second minority opportunity district. Also in Georgia, my law firm brought a lawsuit, and I expect in each of those states you'll see a court order the creation of an additional minority opportunity district. And then the real test is going to be states like Texas, where my firm and others are involved in litigation, and where you could see a number of seats, Hispanic and Black opportunity districts created.
Okay, so is there a world in which the court doesn't add additional minority opportunity districts in these states that you've mentioned? You mentioned Louisiana, Georgia, and Texas. Or will the Milligan precedent now basically ensure that this is what happens?
Yeah, so I think the Milligan case makes sure that will happen in Alabama, really, and also Louisiana. I think Georgia is a half step behind in that the court there has not yet ruled, although I think it is likely to rule following this precedent that the same is true in Georgia, and Texas is a little bit more fluid.
Now, this is kind of a jaded question here, but you know, if anything is come out of watching this political meltdown over the last few years, it's that you become jaded. But why would the court rule this way? Because at least from my perspective, this is a pretty unaccountable branch of government. The conservatives on the court are exceedingly political, and they've allowed their partisan affiliations to color most of the rulings that they've passed down thus far. So why kind of allow this, so to speak?
Yeah, so I think there are a few things going on here that may explain the coalition that you saw in this case of the three liberals, Justice Kavanaugh and the Chief Justice. The first is, remember that when the Supreme Court struck down Section 5 of the Voting Rights Act in 2013, that was pretty traumatic for the country. And the court got a lot of blowback. And that opinion had been authored by the Chief Justice. And in that opinion, he went out of his way to say that nothing in that case would affect Section 2 of the Voting Rights Act, which is what we're talking about here. So part of this may be that the Chief Justice feels like he needed to stay in that lane. Interestingly, Justice Kavanaugh seemed to lean in on the idea of precedence and the fact that in stare decisis, and the fact that this interpretation of the Voting Rights Act goes all the way back to the 1980s and didn't want to overturn that. Now, that's kind of interesting in light of what we saw with Dobbs and elsewhere. But maybe the court just felt like in this area, the law has been so settled that this is where we wind up.
Now, you'd spoken about the Voting Rights Act. What is left of the Voting Rights Act at this point, and how do we salvage it?
Yeah, so there are several parts of the Voting Rights Act. The part that got gutted was a provision that basically said if you're in a state with a history of voter discrimination, before you change your election laws or your districting, you have to get those pre-cleared to make sure that you don't continue to discriminate against minority voters as you have in the past. That's what got gutted. The part that has remained in effect that was really at issue in the court decision today is a provision that applies nationwide. It doesn't just apply to those places with histories of voter discrimination. And what it basically says is that when, for example, you draw congressional districts, if you have a history of racially polarized voting where whites are essentially preventing minority voters from electing candidates of choice, and you have cohesive groups of those minority voters that can form a majority in a district, you have to give them the opportunity to elect a candidate of choice.
Okay. And so is this something to basically bolster the Voting Rights Act, the parts of it that were gutted, like pre-clearance, for example? Is this something that could be basically salvaged, saved, if we legislatively speaking?
Yeah. So look, the first thing to know is that today was a victory, but it was not a restoration of the Voting Rights Act, right? When we talk about the Voting Rights Act, Section 5 being gutted, it is still gutted, and nothing today made that any better. It just did make it worse. What Congress could do is pass a new version of Section 5, a new updated version. And at least if you take the conservatives on the Supreme Court at face value, they might uphold that. Now, that's a big if and might, but Congress needs to try. And Democrats tried to get that through in the last Congress in the For the People Act and the John Lewis Voting Rights Restoration Act. Republicans blocked it in the Senate. And of course, there is no Republican support for it today in the House.
Well, the irony of that then is that this will actually make it easier for Democrats to be able to win the House to then pass something like that that would bolster the Voting Rights Act or a new Voting Rights Act. So, this is just one small step in kind of a long, arduous journey here to get back some semblance of fairness.
Yeah, it's a small step, but it's an important step. I think that's right.
Okay, well, we'll leave it there. One last note here, and that is that Marc and his associates are a major reason that this case turned out how it did. So here's my ask. For those watching, there is one very easy way to support Marc and his team, and that is to subscribe to Democracy Docket. It's the news outlet that he founded. It's free. It's easy to understand. There's no lawyer speak, and it's one of the single best outlets out there. So just go to democracydocket.com and sign up. Again, it will not cost you anything, but that's how we can support the people who are out there fighting for us. So I'll put that link right here on the screen as well as in the post description. And of course, to see more episodes like this, make sure to subscribe to this channel. That link's on the screen as well. I'm Brian Teller Cohen.
I'm Marc Elias.
This is Democracy Watch.